So let's set the scene. You've just gone through a lengthy interview process and you got the job and you're super excited. You just want to fill out the paperwork so that you can get started. You don't want to do anything to jeopardize your offer. So the temptation is just to smash that next button on the digital contract, put your initials, your digital signature on it, and ship it off to HR so that you can get to work. But slow down. It's really important for you to understand what exactly it is you're signing and what kind of restrictions it's putting onto you. And remember that those employment agreements at the companies are written by lawyers, and lawyers are supposed to get the best deal for their clients. So whatever they put in front of you as an employee is not the best deal for you. It's the best deal for them. And it is not a bad thing to negotiate some of these terms. So in this video, I'm going to cover some common clauses in employment agreements that tech workers should be aware of and how to negotiate them. I'm Eric Wise from Foundry, and I've sat on both sides of the negotiating table for contracts. But before we jump in, I have two disclaimers. First, I am not a lawyer. When in doubt, you should always consult a professional. This video is based on things I have personally seen, advice I've given, and negotiating tactics that have worked both on me as an employer and that I've used as a potential employee or contractor. Second, this is United States centric. Even within the United States, the rules can vary from state to state. And this is certainly different here than it is in the international community. A lot of companies, even internationally, have some of the same clauses, but different restrictions. So again, consult your local laws and consult a professional if you have doubts. With all that out of the way, let's jump in. Let's start things off with non-compete agreements. The Federal Trade Commission defines a non-compete agreement as a contractual term between an employer and a worker that prevents the worker from seeking or accepting employment with a person or operating a business after the conclusion of the worker's employment with the employer. Now, this is pretty straightforward. If you sign one of these, you are committing to not compete with your employer. And that means starting your own business or working for a company that is in the business of competing with your employer. Now, the good news is non-compete agreements are falling out of favor in the US. And there's a couple states, including California, where a non-compete agreement is flat out unenforceable. They will not honor them, even if you sign them. Now, as a software developer, you care a lot about non-compete agreements. And let me tell you why. It's because of something called domain experience. You see, the ability to write code is only one piece of the employment puzzle. You also, when you work for an industry like banking or retail or finance, you are building knowledge of how those companies work, how their business processes are put together, rules and regulations. All of this knowledge makes you more valuable to another employer in the same space. So if you sign a really restrictive non-compete agreement, that may mean that you have to change domains, which will be harder. It will make your existing knowledge less valuable, which can take money out of your pocket. And in the worst case, if you can't find a job outside of your domain because it's really specialized, you might have to sit on the sidelines and be unemployed. And who wants to be there? Now, I'm not a fan of non-competes, but in general, a non-compete is going to have two limiters on it. The first may be geographic. So for example, if you're working for a restaurant chain building software and they only have their restaurants in the Midwest of the United States, and you decide to move to the Southwest, take a job there where they don't have any locations, the non-compete may not be enforceable. This is not super common in tech because people work remotely, so the geography tends to be the whole country. The second restriction, which you need for it to even be enforceable, is a time restraint. So how long does the non-compete last? Now, in general, the longer the time restriction is on the non-compete, the more difficult it is for the company to enforce, because courts generally recognize that workers have a right to make a living working in their field. However, most restrictions you're going to see are going to be 3 months, 6 months, 12 months, or if they're really egregious, they might try to get 2 years out of you. And even at the lower end of 3 months, you still need to be wary. You might be okay with 3 months today, but 2 years from now, who knows where you'll be? You might have gotten married, you might have some kids, you might have had to pay to help out a sick relative or something like that, and your financial situation might be completely different. The non-compete doesn't care. So the specter of having to sit on the sidelines and be unemployed for any length of time in your domain is something to be concerned about. So how can we negotiate this? Well, there's a couple things we can do. So first, you can just negotiate the term. Some employers want to get you to work, and they don't want to bother their legal team, and they don't want to have to do this dance with you, just like you don't want to have to dance with them. So sometimes you can just ask to reduce the term, and sometimes they'll just do it. You don't even need a reason. If it's 6 months, ask for 3. See what happens. Nobody's going to rescind a job offer because you ask for a lower term. So that's always the first step. Just ask. Now, second, you can negotiate the exit conditions. So sometimes you leave an employer because you chose to, and sometimes you leave an employer involuntarily, like a layoff. So sometimes you can put a term in there and just say, hey, if you lay me off, if you terminate me not for cause, that's a key word there, not for cause, then I want the non-compete to be reduced or eliminated. And that's something a lot of employers and legal teams are willing to consider, because what they're concerned about as a non-compete is that you're going to take all this knowledge, you're going to quit, and you're going to harm them by going to work for the competitor. But if they lay you off, they're voluntarily terminating your employment, and it's reasonable for you to ask that any non-competes not be enforced in that situation. And third, you can ask for a severance payment. Now, this isn't something that a junior or low-value employee can do, but again, if you're experienced, if you're specialized, and sitting on the sidelines would really hurt you, then asking for a severance to be tied to the non-compete is a reasonable ask. And you can even put it back on the employer and just say, hey, if you're so scared that I'm going to go work for somebody else and harm you, then you should be willing to pay me to sit on the sidelines for a period of time. And you can be really reasonable about it. You can say, hey, you can pick the term, 1 month, 2 months, 6 months, a year. I don't care how long it is, but you need to pay me something if I'm going to stay out of my field of expertise and not use my domain knowledge, which has value. But in the end, you're going to need to decide if the terms that the employer has put in front of you and you've negotiated are worth it. Sometimes you have to just walk away from a position because the terms just aren't good for you in the long run. Now let's talk about non-solicitation agreements. A non-solicitation agreement is a contract in which an employee agrees not to solicit a company's employees or customers for his or her own benefit or for the benefit of a competitor after leaving the company. In plain English, this generally means that you are not going to try to hire away your coworkers, and you're not going to try to steal the company's customers away from them. Now, the first part about not recruiting or hiring your former coworkers, it really depends on what you're leaving the company to do. If you're starting your own business, then blatantly hiring your former coworkers away to come work for you is dubious. You might get in trouble for that. But if you're just going to work for another company It's very easy to recruit your coworkers without getting in trouble. You just go out on LinkedIn and you say, hey, I got this new job and they have more open positions. Nudge, nudge, wink, wink. Or you can talk to recruiters that the other company uses and you can say, hey, if you could go contact these people and tell them that I'm working here and that this is a good place to work, it's really hard to enforce that. The second part about stealing customers is much easier to enforce because as an employee, you usually have visibility into confidential information. You might know what the contracts with the customers look like. You might know what they're paying. And using that knowledge to come in and undercut your previous employer is a really good way to get into legal trouble. So I don't recommend you mess with that. Now, unless you're going to start a new business or become an independent contractor, as a software developer who's an employee, the non-solicit isn't something that you really care to negotiate. If it has a ridiculously long term, like more than a year, you probably want to push back on it, but otherwise this isn't something that you should concern yourself with. Now, on the other hand, if you're starting a company or becoming an independent contractor, getting that term knocked down early on to something shorter and more reasonable is something you want to do. And let me give you an example of how I negotiated one of these clauses for my business. So I had a potential customer and they were buying some education content from me. And they were very concerned that I was going to offer that same content to their customers. They were buying the content because they wanted to offer education services to their customers. Now, naturally, I can't be bound to not solicit their customers if I don't know who their customers actually are. And as an outside vendor, I had no idea. So my negotiating tactic was, hey, you need to give me an up-to-date customer list so that I know who I can't market to. Otherwise, I can't be bound to the terms of this agreement because I could accidentally market to somebody and get into trouble. And when the company really thought it over, they thought, you know what? This is a vendor. We don't want them to know who all of our customers are, and we're just not willing to give them that confidential information. So they ended up dropping that clause out of the contract, and I was able to go on and do business with them. And if I accidentally came across one of their customers and took them, well, so be it. And that's really the main advice I have if you feel the need to negotiate one of these non-solicitation agreements. Just make it really specific. What is a customer? What is an active customer? Because they might try to do things like say, oh, well, we marketed to this company 5 years ago. We've never done any business with them, but you can't talk to them either. So by nailing things down and not making them general, making them specific, you can push back on a lot of stuff that's in a non-solicit agreement. Now that generally refers to people that are starting their own business, contracting, or if you happen to be in a sales or commission role, that's something you can do. Now I've saved the most important clause for last. Almost every contract that a technical professional is going to sign is going to include an intellectual property, or IP for short, agreement. And this clause has restrictions on who owns your work product, your ideas, your code, the things you create, algorithms, inventions, and all the good stuff that makes you money. Now, in most cases, your contract is going to include a clause about work for hire. And what work for hire means is that anything that you do for the employer, you surrender all of the ownership, and that ownership goes to your employer. No muss, no fuss. And most times that's okay. I mean, they're paying you to do a job. It wouldn't be right of you to own the work product because then you could take it away from them. The issue is that some employers' contracts go beyond this. Again, like I said in the beginning, the lawyers are writing contracts to benefit their employers. And I have seen many contracts over the years where the work for hire clause by default grants ownership over anything you do, not just the work you do for your employer. So if you're sitting at home on the weekend off the clock and you decide to make a mobile application that isn't related to your employer's business, they might actually own it. Now, this is where I'm going to get tough on negotiations because this is a hill worth dying on. You should never, as a technical professional, sign a contract that grants the employer rights to any work product that is not directly related to your job and what they're asking you to do. Employers that put these clauses in front of you, it's actually a huge red flag. It's something I have never done in my businesses. I have always structured my agreements such that it is specific to the work that I am paying for. But not all companies do this. And to be fair, sometimes they just grab a template from online and it reads like that. But again, you should never sign that broad of an agreement. As a technical professional, if you're growing and learning, you are going to be doing things on the side. You're going to be building passion projects. You might want to moonlight and do some extra contract work on the side to make extra money. And if your employer owns all of your work product, you are putting that at risk. So again, as a personal example, I create and maintain courseware on Foundry and here on YouTube. I also do a lot of contract work for learning organizations, so they hire me to come in and help them design learning experiences. I always, in my contracts, am very specific about what I own and what I'm doing, and that they don't have any rights to it at all. And if they're not willing to sign that, then good day to you, sir. I will not do business with you. And it's just something that everybody who intends to be a creator of anything should be very wary of. And as part of this, I have to warn you, especially those of you who are just getting into the field. Despite what your contract may or may not say, you should never, ever build anything or work on anything of your own on company time or using company equipment. If your company assigns you a laptop, you never do personal projects on that laptop. You buy your own laptop, you have your own machine. You need to keep a strict firewall in between what your company does and what they give you and what you're using for your own projects. Because if you mix those two and the company finds out about it, you can lose the rights to what you built. So at the end of the day, doing a little bit of negotiation up front can save you a lot of pain, expense, and agony later. Because if you decide that you need to fight a contract that you've already signed, even if you're in the right, lawyer time, legal time is very expensive. So you could end up in a situation where you're not able to work or benefit from your work product, and you're shelling out thousands of dollars in legal fees, and you're waiting for a usually slow court system to wind its way through and deliver you justice. It is not uncommon for large companies to use lengthy legal processes to bankrupt smaller people because they just can't handle the time and money that it takes to get to the resolution, even if they're in the right. So you are much better off negotiating these things up front and walking away if the company isn't willing to be reasonable. But do keep in mind that some of these restrictions, from an employer's perspective, are reasonable. Your personal situation matters. The company's situation matters. And again, if there's any doubt, spend a couple $100, go talk to an employment lawyer. They'll generally give you good advice and help you edit those contracts. And if you do those things, you're going to be a much happier coder.